Where're the witnesses?
Thank you, sir. We've got the second witness. Thank you.
Committee will come to order. Let me begin by thanking all of you for being here. When the committee held its first hearing on the Bank of America Merrill Lynch merger over 5 months ago, I asked a few simple but vital questions. First, how did a private sector deal announced in September 2008 wind up as a major government bailout, with the taxpayers on the hook for $20 billion? Second, I asked whether the government forced Bank of America to go through with this deal. Finally, I asked whether Bank of America CEO Ken Lewis really had a legitimate basis for backing out of the Merrill Lynch deal, or when he realized late in the game that there were serious problems with the deal, did he threaten to back out to gain leverage for a taxpayer bailout? Today, as a result of our investigation, I think the answer to those questions are much clearer. Each senior Bank of America executive who was involved in the deal has told the committee that the government did not force them to go through with it. Ken Lewis has also told us that nobody in the government did anything improper during this transaction. If there are still people who want to say the government forced Bank of America to go through with the deal, they are turning a blind eye to the facts we have before us. A simple but important fact is that the government did not elbow its way into this transaction. Ken Lewis called then Treasury Secretary Hank Paulson on December the 17th, 2008, and brought the government to the table. That one phone call started everything in motion. On that phone call, Ken Lewis claimed that he believed Bank of America could back out of the deal with Merrill Lynch based on the material adverse change clause in the merger agreement, the so-called MAC clause. What we know now is that Bank of America top lawyer Tim Myopoulos told two top Bank of America executives on December the 1st, 2008, that Bank of America did not have a MAC. Mr. Myopoulos was suddenly fired 9 days later without explanation and replaced by a senior insider who had not practiced law in years. Our investigation has also uncovered documents showing that on December the 15th, 2008, lawyers working for Bank of America knew that to win a MAC, it is not enough to show a short-term earnings decline, no matter how severe. Must show decline in value over a period of years, not months. Nonetheless, Ken Lewis called Hank Paulson on December 17th and said Bank of America actually had a MAC. Again, on December 19th, lawyers working for Bank of America gave its executives a memo that noted that Delaware courts had never found that a MAC occurred, allowing the buyer to terminate a merger agreement. Excuse me. Nonetheless, 2 days after receiving that memo, Mr. Lewis again called Secretary Paulson and threatened to back out of the deal. Finally, the committee has obtained notes showing that Bank of America outside counsel believed on December the 18th that they had at least an 80% chance of losing a MAC claim. Perhaps the most telling of all documents is the one where a lawyer of Bank of America writes, and quote, "Threat of MAC, don't push too far. It could turn against us." The documents and testimony the committee has reviewed clarify that the Bank of America was aware that the chances of prevailing on the MAC were very slim. Merely invoking the MAC could have led to significant adverse financial consequences for the company. Based on the fact we have before us, it sure looks like it was a Bank of America that was holding the shotgun at this wedding. Today we will hear from Tim Moopoulos, the lawyer who was fired 9 days after telling Bank of America executives there was no MAC. We'll also hear from Brian Moynihan, the person who replaced Mr. Moopoulos, excuse me, and who determined sometime between December the 15th and 17th that Bank of America could back out of the deal by invoking the MAC. After replacing Mr. Moopoulos, Mr. Moynihan served as the general counsel for about 44 days. He stopped serving as the general counsel about 6 days after the bailout was a done deal. He is now president of Consumer and Small Business Lending at Bank of America. We will also hear from two Bank of America directors who were on the board when this deal and the bailout went through, and who now are helping choose the next Bank of America CEO. At this point, our investigation has shed a great deal of light on a deal that was secretly made and at the cost of the taxpayers' billions. Although the investigation may be coming to a close, I am certain that no member of this committee will stop working until all the taxpayers' dollars that Bank of America received are paid back. Thank you very much. And on that note, I yield to the ranking member of the committee, Mr. Darrell Ice of California.
Thank you, Mr. Chairman. I have greatly appreciated your willingness to engage in necessary oversight of the Bush administration, I repeat, the Bush administration's decision to force Bank of America and other banks to accept TARP funds and subsequently force Bank of America to acquire Merrill Lynch. Unfortunately, the bipartisan nature of the investigation appears to have stalled at today's hearing. First, Mr. Chairman, there has never been a shotgun wedding in which the groom held a shotgun to himself. As you have said in the past, this was a shotgun wedding, and the only people that could have held the shotgun was the Bush administration, Paulson and Geithner, and we all know that. I regret the investigation today has now become a apparent cover-up of the continuing activities of the Obama administration, and particularly Secretary Geithner. In securing promises of billions of dollars of taxpayer support in exchange for Bank of America's waiver of its contractual right, even if it was only 20% likely, to attempt to negotiate a lower price using that 20% likely MAC clause for Merrill Lynch. At one time, Mr. Chairman, you were willing to follow the trail of misconduct wherever it led. Now that the trail may lead to a cabinet officer in the Obama administration, this committee's time and resources have been redirected toward the political scapegoating of Bank of America. As a businessman, I said some time ago that I saw through what Ken Lewis was doing. What he had losses which, if put back into the correct places they should have been, in other words, recalculating the profits not made as a result of those losses, he had a good case for a MAC. He had a good case for saying in an Enron-like fashion that, in fact, Merrill Lynch had overstated their profits by booking these as good when, in fact, after the fact, they were known to be wrong. That's no different than Enron. You can't call a profit when it's clear that it ultimately was a risky investment likely to lead to failure, and, in fact, it had led to billions of dollars in failure. Ken Lewis was doing what most tough negotiators do, found an opportunity to get a dramatically better price, one that would have saved his company money and ultimately the stockholders' money. And yet, the Bush administration, under Secretary Geithner, then Fed Chairman of New York, and Secretary Paulson, forced the issue and used money, both literal and figuratively, as justification for why they must go through. Literally, because they offered the money, and Secretary Geithner offered it repeatedly verbally during the transition team. Figuratively, because they offered to take Ken Lewis and his company down if they later needed money and did not go through with the merger. Bank of America CEO Ken Lewis repeatedly asked the Bush administration to put purely verbal comments for additional taxpayers' money into writing. But both Hank Paulson and Ben Bernanke refused. Instead, they sought to control disclosure for this new bailout until the last possible date. The incoming Obama administration's support for the commitment of billions of additional taxpayer dollars was absolutely essential to ensure Bank of America's cooperation in this purely verbal backdoor deal. Mr. Chairman, we do not want to see lawyers doing verbal things, and yet in this case we had no memos that we could rely on and no written contracts. Mr. Chairman, where is Tim Geithner, who could in fact verbally and under oath give us the answers to our questions? The fact is, where is Sheila Bair? Where in fact is Mary Shapiro, or even where is Chris Cox? Where is the government? Change has come, Mr. Chairman. Under the Bush administration, whether Republicans or Democrats were in charge of this committee, we brought in administration officials. The witnesses we're going to hear from today are appropriate, and they will speak to their view of what happened. But we've already had Ken Lewis here under oath testifying to his explanation of what happened, and it has not been refuted by any of the subsequent documentation, discovery, or testimony. Mr. Chairman, as a ranking member, I do not have subpoena authority. As ranking member, I do not have the ability to get a witness. As ranking member, I will be asking for, in writing, another minority hearing. I will because, in fact, we had majority and minority agreement on this panel and the panel which is not here today. Mr. Chairman, my request for a minority hearing will be for the exact people that you have chosen to drop off of this list after agreeing. I ask for nothing more. Mr. Chairman, it is very clear that we cannot feel that change has come and therefore the Obama administration no longer can make a mistake, even when in fact the people who made the mistake under the Bush administration are now in the Obama administration. With that, I yield back.
Here we go again. Let me say that if the ranking member would like for me to pull out a calendar, I am happy to do so and remind him that this merger and bailout occurred during the previous administration. And if he had such strong feelings and concerns about it, this bailout, I wonder why he was not asking the Bush administration the tough questions last year. I now yield to the gentleman from Ohio.
Thank you very much, Mr. Chairman. This investigation started with questions: how could a merger of the largest bank and second largest investment bank in the country require a government bailout only weeks after shareholders had voted to approve it as a private deal? Was it true that the financial situation shifted so dramatically in that short amount of time? Or did top management know, or should they have known, about the changing situation much earlier? Did they fail to make necessary disclosures to their shareholders? When we asked Ken Lewis, Bank of America's CEO, about this at our first hearing, he told us that he relied on the advice of counsel and that he relied on forecasts from Merrill Lynch. Recently, in response to our request, Bank of America produced to us the documents on which they based their decision not to make additional shareholder disclosures, as well as the notes from some of the discussions that led to that decision. This included the actual forecast that was created by Merrill Lynch and used by Bank of America's lawyers as a basis to determine if there was something shareholders should know before they approved the merger. Our examination of this forecast and how it was used should sound alarms about how Wall Street really operates. The forecast, when it was created by Merrill Lynch on November 12th, revealed that in October, the company had absorbed in just 1 month more losses than in the entire previous quarter, and half the amount of losses in the fourth quarter of the previous year. Yet, incredibly, the forecast omitted to make any projections of how the most troublesome investments, collateralized debt obligations, subprime mortgage-backed securities, credit default swaps, would perform in the next 2 months, November, December. The forecast assumed those investments would have zero effect on Merrill Lynch's bottom line for 2/3 of the remaining fourth quarter. Bank of America saw the deficiency in the document, but they've not shown us that they actually did any actual analysis to make up for Merrill omissions. On the contrary, the evidence we have suggests that Bank of America pulled a number out of thin air. Far from being consistent with the actual experience of October or what they knew about the third quarter, the guests wishfully assumed that the markets for collateralized debt obligations and credit default swaps would be significantly better in November, December. It was assumed that Merrill Lynch would almost break even for November, thereby spreading October's bad results over 2 months. Then the attorneys at Bank of America and Wachtell Lipton went to work. They did not question the financial information they were given. They began with the assumption that additional shareholder disclosure was necessary, and they discussed what kind of disclosure they would make. But after studying the question for a week, they decided that the news was not sufficiently out of line from past performance and previous disclosures to warrant further shareholder disclosure. Thus, on the advice of counsel, Bank of America did not make any further disclosures to its shareholders in advance of the merger vote. Within only weeks, however, reality crowded out the wishful thinking. Far from having a small effect, those collateralized debt obligations and other exotic instruments continued to lose large amounts of money. Bank of America's guess, which had played a significant role in the decision not to make additional disclosures to shareholders, proved to be billions off the mark. That's when Bank of America went to the U.S. government for help. This investigation has opened up a rare window onto the management suite of the largest bank in the country. Here's a story of how Bank of America's top executives allowed guesswork to masquerade as actual expert knowledge, and how numbers pulled out of the air without any actual analysis served as the basis for corporate decisions made about other people's money, shareholders' money. Unfortunately for all of us, I doubt Bank of America is unique. Look around to see what the geniuses of Wall Street have wrought. The house of cards they have built that have buried our constituents under debts they can't pay, record rates of foreclosure, and joblessness. If you think these bankers and financiers deserve the millions of dollars they're paid and the bonuses they award themselves, if anyone thinks they can be trusted with running companies that are too big to fail, think again. The wizards of Wall Street are no more wizard than the Wizard of Oz, except, unlike the Kingdom of Oz, when that kingdom falls, there's wreckage all over America. I yield back.
Thank you very much. I now yield to the gentleman from Ohio.
Thank you, Mr. Chairman.
Jordan.
Mr. Chairman, I just want to respond to your previous statement. This is not about one administration, holding one administration accountable and not the other. This is about holding government accountable. I mean, that's this committee. This is the Government Oversight Committee, and the ranking member's suggestion that we need Ms. Shapiro, Mr. Cox, Ms. Baer, Mr. Geithner here is exactly on target. No one, in our previous hearings, which I appreciate, no one went after the previous administration, specifically Secretary Paulson, harder than ranking member Issa and myself. We just want the opportunity to go after the same folks, question the same folks who were now in our current administration who were involved in this decision. The chairman mentioned shotgun being held to people. I mean, the only shotgun involved here was what the government held to Bank of America's head when they forced them to take I mean, think about 9 days after this passed, they forced Bank of America, when Bank of America had to sit down with the 8 other big institutions in this country, forced them to take TARP money. And then in the deal itself, That's why we need officials who were involved in this whole decision here. As I suggested in some of our previous hearings, I think Mr. Paulson actually misled the Congress when he came in front of the Congress last year, asking for the TARP money, and then, as I said, 9 days later, changing course dramatically and saying we're not going to purchase any of these mortgage-backed securities. We're just going to give capital to the banks. So the question that Mr. Issa asked, I think, is right on target. The unprecedented moves we've seen from the government, the unprecedented pressure we've seen from the government on this institution, I think, requires us to get Mr. Geithner, Mr. Cox, Ms. Baer, Ms. Shapiro in front of this committee. And I hope that the chairman will do that so we can have a full airing of what took place and ask the appropriate questions. And with that, I would yield some time to the ranking member if he'd like. If not, I'd yield.
I thank the gentleman. I just want to set the record straight a little bit because I think it's important. First of all, we understand that we're not the Financial Services Committee. The SEC does not report to us, and in fact, the SEC has more jurisdiction over this commercial portion than we do. But we are the Government Oversight Committee. And I would join with my colleague from Ohio, in this case, Marcy Kaptur. We led the charge and worked to try to defeat the TARP because we knew that the money would not be properly spent the way the administration brought it to us. And as it turns out, just days after they got the money, they spent it in a very different way. So I think that when we're setting the record straight, we're setting the record straight that we didn't think the last administration should have these hundreds of billions of dollars of walking around money loosely disguised as an emergency fund for a specific reason, and that, in fact, a merger which was approved on December 5th, consummated around December 17th, consummated on December 31st, in those 20 days that President Bush was still in office, there wasn't any oversight we could have done. We weren't even in session except to organize. What we did do is those of us who fought on a bipartisan basis the funding of TARP continued to say that these were outlandish ways to spend the money, that this was wrong for us to be part and parcel of mergers and acquisition and price setting. And so today, I think this committee needs to stand up to what we were doing in the last Congress and continue to look at where government failed us. And it doesn't matter whether it was Republican or Democratic government, we need to continue to do that. And we certainly need to see that the remainder of the TARP not continue to be spent in a way that you yourself, Chairman, have called a shotgun wedding. And I thank the gentleman for yielding.
Thank you, Mr. Chairman. I yield back.
Let me just say that before we move forward, you know, I think that to make that assessment before we hear from our witnesses, I mean, you don't know what they're going to say, how much they're going to say, and based on the fact that what has been said up to this point, you know, by Mr. Lewis, who indicated that the government in no way acted improper. I mean, this is what he said. Now, the question is, if you don't believe in terms of his comments or his statement, then that's another issue. But in the meantime, we're going to move forward. Will the witnesses please stand? Do you solemnly swear to tell the truth and nothing but the truth, if so, please answer in the affirmative. Record reflect the answer in the affirmative. You may be seated. Going from my left to right, our witnesses today are Timothy Moopoulos, was General Counsel of Bank of America for nearly 5 years, from January 2004 until December the 10th, 2008. He is currently the Executive Vice President of General Counsel and Secretary of Fannie Mae. Mr. Moynihan was the General Counsel of Bank of America from December the 10th, 2008 to January 22nd, 2009. He currently serves as the President of Consumer and Small Business Lending at Bank of America. Mr. Guilford and Mr. May are currently on the Bank of America Board of Directors and were on the board last December when the bank received its bailout. They are both also on the committee that is selecting the replacement for Mr. Lewis. Mr. Moopoulos, please give your opening statement, and you have 5 minutes, and of course, and the light starts out on green, then it turns to yellow, and then of course it turns to red, and when it gets to red, we ask if you would stop, which will allow the members an opportunity to be able to raise questions after all the witnesses are finished. Thank you.
Chairman Towns, Ranking Member Issa, and members of the committee, thank you for the committee's invitation to appear before you today. My name is Tim Moopoulos. Bank of America recently waived its attorney-client privilege with respect to the Merrill Lynch merger and has
You want to pull the
instructed,
mic a little closer to you?
me that I am free to answer questions the committee may have for me. Accordingly, as the committee has requested, I will briefly summarize and have set forth in more detail in my written testimony the legal advice Bank of America received in connection with the Merrill Lynch merger, as well as the circumstances of my departure from the company on December 10, 2008. I served as General Counsel of Bank of America for 5 years. I was responsible for overseeing a very large number and wide range of legal matters. In the case of the Merrill Lynch merger, I relied heavily on the company's outside counsel, who were leading lawyers at the esteemed law firm of Wachtell, Lipton, Rosen & Katz, as well as my own in-house legal department. Questions have been raised about what legal advice Bank of America received as to whether to disclose to shareholders the amount of the potential 2008 bonus pool for Merrill Lynch employees. To my recollection, I had no role in this issue. I do not recall anyone raising or discussing with me whether the potential year-end bonus pool for Merrill employees should be disclosed to shareholders. As far as disclosure was concerned, as was my practice, I relied on Wachtell Lipton and our in-house legal staff to prepare the proxy statement properly and accurately. The committee has asked what legal advice Bank of America received regarding the material adverse change provisions of the merger agreement. The only advice I recall giving about these provisions was on December 1, 2008. I advised Joe Price, Bank of America's Chief Financial Officer, and Greg Curl, then Bank of America's Head of Corporate Strategy, that for Merrill's poor financial performance to constitute a material adverse change, it had to be disproportionate to that of other companies in the industry, including Bank of America. We discussed the relative performance of the two companies since the merger had been announced, and I advised Mr. Price and Mr. Curl that there was no basis to conclude that a material adverse change had occurred with respect to Merrill Lynch. The committee has also asked what advice Bank of America received with regard to whether it should disclose Merrill Lynch's projected losses for the fourth quarter of 2008. The Wachtell Lipton lawyers and I gave advice on that topic to Mr. Price. Everyone involved concluded that disclosure of the projected losses was not warranted. There were a number of reasons. First, because the materials announcing the merger and the proxy statement did not contain any projections or estimates of Merrill Lynch's future performance, there was no legal duty to update past disclosures about future performance. Second, Merrill Lynch's recent financial performance put investors on notice that Merrill might well suffer multi-billion-dollar losses in the fourth quarter. Over the 12-month period beginning with the fourth quarter of 2007, Merrill Lynch had experienced after-tax losses of approximately $22 billion for an average quarterly after-tax loss of more than $5 billion. Third, the proxy statement and other disclosure documents clearly informed investors that unprecedented adverse market and business conditions could continue to impact Merrill Lynch negatively. Finally, there were also many highly publicized events that were warning signs to investors that financial institutions would remain under great stress and might continue to incur significant losses, including, among others, the near failure of Bear Stearns, the collapse of Lehman Brothers, the government's rescue of AIG, and the government's extraordinary actions to authorize the expenditure of $700 billion to try to save the financial system. Moreover, the estimates were based in part on guesses as to what the loss would ultimately be. It is obvious in hindsight that if either the $5 billion or the $7 billion loss estimates, of which I was informed, had been publicly disclosed to shareholders at that time, shareholders would have been misled, as these estimates turned out to be wildly incorrect. No one ever suggested to me that the losses were expected to reach $15 billion, as they ultimately did. With regard to my departure from Bank of America, Amy Brinkley, the company's chief risk officer, advised me a little before noon on December 10, 2008, that Ken Lewis had decided to replace me as general counsel. Ms. Brinkley said I was being terminated effective immediately and that I was to leave the premises immediately. I was stunned. I had never been fired from any job, and I had never heard of the general counsel of a major company being summarily dismissed for no apparent reason and with no explanation. I cannot tell you why I was fired. I don't know. After I left Bank of America on December 10, I was never consulted about any of the matters I had been working on. Accordingly, I cannot tell you what legal advice the company received after I was gone. I can assure the committee that at all times I acted in good faith to provide legal advice that I believe to be appropriate, considered, and in the best interests of Bank of America and its shareholders. I did my best to be a good, careful, and honest lawyer. I would be pleased to answer any questions that members may have.
Thank you very much, Mr. Marpolis. Mr. Moynihan.
Good morning, and thank you, Mr. Chairman. Congressman Issa, Subcommittee Chairman Kucinich, Ranking Member Jordan, and the rest of the committee. My name is Brian Moynihan, and I serve as the President of Global Consumer, Small Business and Card at Bank of America. Prior to that job, I served in many capacities, including running the group that Merrill Lynch came into in January 2009. I also served as Bank of America's General Counsel, and prior to that, I served as Deputy General Counsel for a predecessor company. And prior to that, I was a law partner in private practice, and I specialized in merger and acquisition, financial institutions, securities law, and other matters relating in particular to the financial sector. I want to touch on 2 points today. First, well, not the specific point, but the backdrop of this committee hearing. I want to briefly discuss how our company, Bank of America, continues to help homeowners, families, and businesses weather the economic challenges we all face. And second, I want to talk about how our acquisition of Merrill Lynch helped prevent a further financial collapse last winter. The deal turned out to be a good deal for our shareholders and our customers. But most importantly, it turned out to be a good deal for the taxpayers who provided assistance. We acted in good faith in the best interest of our shareholders and the country in mind. Let me turn to my first point. I know you hear from constituents, as we hear from our customers, about the challenges they face in today's economy. Bank of America is doing all we can to help them. We understand the public expects that of us, especially as a financial institution that receives taxpayer assistance. As we recently announced in our quarterly lending and investment report, we have extended $759 billion in loans since our first report late last year. That represents $17 for every dollar of financial assistance we've received. Making home loans is a priority for our company. In the first 9 months of 2009, we've made almost $300 billion in home loans available to over 1 million customers. We've also made $255 billion of credit available to large and small businesses. In addition to that, we've made $26 billion in credit available to municipalities and other nonprofits. All these figures don't include the $1.5 trillion that we've committed to invest in low and moderate income communities around our country, and also don't include the $200 million in support we provide to charitable organizations on a yearly basis. I now turn to my second point, the topic of today's hearing. I think it's important to keep one thought in mind throughout our discussion today. Although the Merrill Lynch transaction and Merrill Lynch itself as a company was severely impacted by the worst dislocation that the financial markets had seen since the Great Depression, our acquisition of Merrill Lynch is a success. First, the acquisition has provided great benefits to our customers. A stable Bank of America Merrill Lynch platform can simply provide more capital to more businesses in these tough times. Second, the taxpayers are also benefiting from a stronger financial system and more directly in the form of the financial return they're receiving on their investments. Third, closing the transaction in December 2008 was in the best interest of the financial system, the economy, and the country. As the committee has heard in prior testimony, the failure of Merrill Lynch in December 2008, particularly on the failure of the Lehman Brothers and other financial firms, would have exacerbated the economic havoc that our country faced. And I'm proud that Bank of America stepped forward. Bank of America has cooperated and will continue to cooperate with this committee to help develop a better understanding of the circumstances surrounding this transaction. The record created by the testimony and those documents shows, and I hope my testimony today will help further demonstrate, that throughout the deliberations with Merrill Lynch around the acquisition, Bank of America acted in good faith and consulted with one of the premier law firms in the country to address very difficult issues. Business people, confronted with complex business and legal issues, acted in an open and honest manner. All the parties involved, including the lawyers, did their level best to address and balance the merits of these complex questions in a time of great stress and in the face of unprecedented economic conditions. Thank you for the opportunity to make this statement, and I'm pleased to answer your questions.
Thank you very much, Mr. Moynihan. Mr. Gifford.
Chairman Towns, Ranking Member Issa, Subcommittee Chairman Kucinich, Ranking Member Jordan, my name is Chad Gifford. I have been a member of the Bank of Board of Directors since 2004, when Bank of America acquired Fleet Boston, where I had served as Chairman and Chief Executive Officer. I was Chairman of the Bank of America Board from April 2004 to January 2005, and I have continued to serve as a member of the Board since then. Mr. Chairman, I understand the committee's interest in gaining my perspective on Bank of America's acquisition of Merrill Lynch.
Sorry, sir.
Oh, sorry. I assume I don't need to go again, Mr. Chairman. Okay, thank you. I would only like to make two observations at this point. First, I believe the Bank of America-Merrill Lynch combination is already bearing fruit. Merrill Lynch has been accretive to Bank of America earnings for the year to date, and the systemic benefits envisioned when the board approved the merger are already beginning to take hold. Although it is fair to say I had a number of probing questions about the transaction at the start, I firmly believe that over the long haul, Merrill Lynch will continue to be an important contributor to Bank of America's profitability. Second, as someone who has spent his entire professional career in the banking sector, I can attest that the financial crisis of 2008 was simply unprecedented in its depth, breadth, and velocity. Even in the midst of it, predictions of how bad it would get consistently understated the scope, the severity, and its duration. Our government, elected and appointed officials, took bold action and made extraordinary decisions to stabilize the financial system. For these measures, those of us in the banking industry should be grateful. I want to take this opportunity to personally say thank you to the American people. As the process of the recovery moves forward, admittedly slowly, we at Bank of America will always remain mindful of what was done to stabilize our system and of our important role in helping these decisions work for our customers, families, businesses, and investors. Thank you again for the opportunity to participate in today's hearings, and I too look forward to your questions.
Thank you. Thank you very much, Mr. Guilford. We were caught off guard with your shortness. I mean, that's unusual around here. We generally have to stop people. So thank you. Mr. May.
Chairman Towns, Ranking Member Issa, Subcommittee Chairman.
Is your mic on?
Kucinich, yes it is. And Ranking Member Jordan, my name is Tom May. I am Chairman, President, and CEO of NSTAR, a Massachusetts-based public utility holding company, and I have been a member of the Bank of America Board of Directors since 2004. I also appreciate the opportunity to be here today to discuss Bank of America's acquisition of Merrill Lynch. I'd like to associate myself with the remarks of Mr. Gifford and Mr. Moynihan so that I can be brief also. The Bank of America Merrill Lynch merger is working, thanks in no small part to our extraordinary associates. We all remain mindful of the extraordinary circumstances the global financial system faced in late 2008, the assistance we received to complete the Merrill merger, and the commitments we made at that time to the American taxpayers. We look forward to fulfilling those commitments and to ensuring that the Bank of America and Merrill Lynch continue to provide exceptional value to our customers and our investors. I also am pleased to answer any questions you may have today.
Thank you very much. Let me thank all of you for your testimony. Let me begin with you, Mr. Maopoulos. On December the 1st, 2008, did you tell Bank of America CFO Joe Price that you did not think Bank of America could back out of the Merrill Lynch deal, invoking the MAC?
Yes, Mr. Chairman, I gave that advice.
Were you fired 9 days after giving that advice?
Yes, Mr. Chairman, I was.
Do you know why you were fired?
No, Mr. Chairman, I don't know why I was fired. I don't know whether it had anything to do with the advice I gave or might give, or whether it had to do with something else. I don't know why I was fired. I wasn't given an explanation.
Did you at any point have a conversation with Ken Lewis talking about your role after the merger of Bank of America and Merrill Lynch? At any point did they talk to you about what your role would be after that?
Yes, Mr. Chairman, on the evening that we negotiated the Merrill Lynch merger, Mr. Lewis told me personally that I would be the general counsel of the combined company following the merger.
But it didn't happen?
No, sir, it didn't.
Let me just move forward to you, Mr. Moynihan. Just to make sure I'm clear, did anyone in the government force Bank of America to go through with this deal?
No, sir.
No one in the government?
No, sir.
We know much more now about the MAC and this entire deal than we did last summer. If you believe there was something material about the Merrill deal that made you want to back out of it, why didn't you think it was material to the average American who was thinking about buying some of your stock and disclosing it publicly?
Mr. Chairman, when I became General Counsel and we worked and looked at the $18 billion loss that we were facing at Merrill Lynch, we believed we had a valid claim for a MAC. The disclosure requirements would arise when we had a duty to disclose those, which was later when we announced our earnings in January.
Being you're sitting next to Mr. Maopoulos, let me ask you a question. Did you think he was a good lawyer? Being you're sitting next to him.
Yes, sir, I did think Tim was good General Counsel.
I'm sorry, Mixon.
Yes, I did think he was a good General Counsel.
Do you think it made sense to fire someone who had been the top lawyer for the previous 5 years, especially right in the middle of one of the biggest deals in Bank of America's history? Didn't you feel uncomfortable with that?
Mr. Chairman, the times that we were going through in December 2008 was we were downsizing the company relatively dramatically, and we were changing 10% of our executives were terminated, and which is terrible things and terrible times to go through, but part of the economic stress. And the changes that were made, as best I know, were made as in the context of us changing the numbers of senior executives we had because of the economic stress we were under. It's a tough thing to go through, but it's part of being about business, and I think it's clear that that's what drove the decision.
Yeah. I just wanted you to repeat one thing. There's some question about the government's involvement here. The government did not pressure you at any point to do anything that you did not want to do?
I did not personally feel at any point pressure by the government to do something that was not in the best interest of our shareholders.
Thank you. Thank you very much. Mr. Gifford, the committee has obtained 2 emails you sent regarding the Bank of America's deal with Merrill Lynch. In one of those emails, you used the phrase, screw the shareholders. Screw the shareholders. And the other, you expressed disagreement with the way Bank of America approved mergers. Can you tell us any more about what you had in mind when you wrote those emails? Is there anything else you could tell us?
Yeah, I can, Mr. Chairman. I'm obviously not terribly proud of the choice of words, to be sure. The first reference to an email was, as I recall, the middle of January. And it happened during the middle of a board meeting in an exchange with a very good friend, and we were being rather informal, as the words might suggest. And we were going back and forth, and it was during that meeting that we were announcing earnings for January for the fourth quarter in the year, which were certainly unsatisfactory, and we knew would have a very negative effect on share price. We also eliminated the dividend down to a penny. What I was doing, for me, my holdings in Bank of America are very significant for me and my family, and so you took it a little out of context. The actual expression or the actual line was, unfortunately, it's also screw the shareholders. I don't like saying that word in a public forum. And what I was doing is expressing remorse for all shareholders.
Right. Let me just ask this very quickly before we move on. Mr. May and, of course, and Mr. Gifford, Ken Lewis told this committee that he and the board ultimately decided to go through with the Merrill deal because it was in the best interest of the company. Do you agree that buying Merrill Lynch was in the best interest of Bank of America?
Yes, I do, sir. Back in September, when the board was first presented with this opportunity, after many probing questions, I might add, because these were difficult times, it was not a, if you will, a slam dunk transaction. But in my opinion, the long-term strategic benefits were such that I voted for the transaction.
I also voted for the transaction, and to this day still feel that it is a tremendous combination of 2 wonderful companies.
You'll give 5 minutes to the gentleman from California.
Thank you, Mr. Chairman. And thank you both for your doing your fiduciary duty. I'm sure it was not easy, as 10 10 than $18 billion of unexpected losses piled up at a company in the middle of a merger. I've done a few acquisitions in my day and still sit on the board of my company, and I wouldn't want to try to decide whether to pull the trigger or not pull the trigger with so many people on both sides, and particularly at a time when Secretary Paulson and President Bush himself were up here on the Hill telling us it was a crisis, and if we didn't vote money in a matter of hours, the world as we know it was going to come to an end. And of course, as you know, the world as you know it never comes to an end in Washington because we just print money. We've had no layoffs. Mr. Moynihan, it won't surprise you, but government has grown net by 139,000 new employees just since this administration took office. We don't feel your pain. But let me go through a couple of set the record straight. If we could put up slide 1. Slide 1, when it gets up there, it's hard to read, but it says, before formally call Mac, get government in. Geithner gone on vacation. This is from Eric Roth, B of A lawyer. Then slide 2. Fire board if you do it. Tim G. agrees. Larry Summer and Tim agree. This is from Joe Price, one of your CFO of the company. Slide 3. Hank Paulson made it clear that Treasury and the Fed were prepared to deliver an assistance package. Hank made it clear that he had concurrence of the Fed and Tim Geithner and others. Ben also stated that Geithner and, in addition, Larry Summers were both on board with this transaction. Those, Mr. Chairman, are the words of Ken Lewis. Slide 4. Ben says $45 billion TARP available if necessary. Obama team informed and agrees. Tommy Franks, B of A board member. Slide 5, not here today, of course. Slide 5. Incoming team at Fed and Treasury in agreement. This is from another board member not here, Tim Sloan of your board. Slide 5. Slide 6. Paulson and Bernanke spoke to Geithner. You have our commitment that this will be resolved. You will get some additional investment. Eric Roth, B of A lawyer. Questions for you gentlemen. None of these are in dispute here today. None of the testimony that we've had up until now disputes the fact that in various ways then Fed Chairman or then Fed New York Bank Chairman Tim Geithner was in the loop because this was after he was the likely and in fact now is the Secretary. Knowing all of this, do you believe today that if the money had not been made available, and this is for the board members primarily, in the form of a loan or in this case a loan through preferred stock with interest, do you believe that you would have likely pulled the MAC and disputed going through with the deal at the current cost based on the $18 billion in losses? And Mr. Gifford, particularly I'd like you to answer that since your career has been in banking. If you take $18 billion out of your balance sheet and then try not to have the FDIC come in and take you out, isn't that a real concern that you would have had to deal with?
Ranking Member Issa, it was a confusing time for sure. I can tell you that as we learned, we the board, originally on December 19th of the growing and very significant losses at Merrill Lynch, management presented to the board the opportunity to exercise the privileges of a MAC, a Material Adverse Exchange Clause, and get out of the transaction because of the how much damage had been, if you will, invoked on Merrill Lynch. It became, we then talked later with Mr. Lewis, we being the board, a few days later, and he expressed the fact that the government thought it would be a major mistake for us to walk away. They thought it would be a very dangerous systemically, and very dangerous and not positive at all for the Bank of America.
And let me just interrupt you. Did he express that if you walked away from it and then needed help later, the Fed wasn't going to be there for you?
No, he didn't. He expressed the sentiment, and there was another session later in the month that the government would provide financing. There was nothing in writing. but it was from very senior officials of the government that one would believe would follow through. The details were not reviewed with the board. I can tell you, as a member of the board of directors, I can only speak as one person. The issue was relatively clear to me. In a perfect world, it would have been better to walk away.
Sure. One last question for the two of you very quickly. As CEOs, as business leaders who have had general counsels, don't you normally require two things? Your general counsel give you honest statement, which you take his legal advice, but don't you need to have at all times a general counsel who's on board with your leadership decisions?
A general counsel who's on board with our leadership decisions?
In other words, would you keep a general counsel who's constantly telling you not to do what you've already decided to do from a business standpoint?
Well, I mean, any member of the board has to make up their own mind. You would like to be in a position to believe your general counsel is going to provide good counsel.
Mr. May?
Yep.
I agree with that totally.
Gentleman's time has expired. I now yield 5 minutes to the gentleman from Ohio, Congressman Kucinich.
Thank you, Mr. Chairman. I ask unanimous consent to enter into the record documents that will be part of this question.
Without objection, so ordered.
Thank you. Mr. Mayopoulos, as General Counsel at Bank of America, you determined whether or not the bank made additional disclosures to shareholders to update its proxy solicitation. What threshold of quarterly losses would have led you to recommend additional disclosure to shareholders before the vote? Wasn't that threshold anything above a $10 billion forecast quarterly loss?
Congressman, the historical experience at Merrill Lynch over the prior 4 quarters, it had quarterly losses ranging from $2 billion to $10 billion. Certainly, as you got to $10 billion or higher in after-tax losses, I think the case for disclosure became much more compelling.
You state in your testimony that you received a copy of a forecast dated November 12th, and that the information in it played a role in your legal deliberation about making additional disclosure about the financial situation at Merrill Lynch. Let's look at the November 12th forecast you received. Our staff has already provided the gentleman with a copy of what we're talking about here. Merrill Lynch's most illiquid and volatile assets, the collateralized debt obligations, the credit default swaps, and subprime mortgage-backed securities, were tracked in the rows marked significant items, total marks. Now, if you follow that across to the column entitled BTG, which stands for balance to go, or the estimate of performance for the remainder of the quarter, in that gray highlighted box, they're blank. There are no numbers there. Is that correct?
I don't see any numbers there, sir.
Okay. So there's no projection for collateralized debt obligations and other illiquid assets that were losing a lot of money at that time. When my staff asked Merrill Lynch's CFO, whose team produced this spreadsheet, why a forecast would contain no projections for these assets, he told us that this document was not intended to be a valid forecast despite its title. Mr. Mayopoulos, did you notice that omission, and did you ever question whether or not the November 12 forecast document was a valid forecast?
Representative, no one ever told me that this was not a valid forecast. I was informed.
So that's a no?
That's a no. I was never told it was not.
Well, I need to move on here. I want you to look at the bottom margin of the page. Those notes were added, we understand, by Bank of America's treasurer to the Merrill Lynch forecast document on the morning of November 13th. They were intended to help fill in the omission noted above. Can you read those lines aloud?
There's a line that says minus 075 Alt A from OCI to P&L.
Okay, I'm referring to the line that says Neil gut question mark. Now, was your understanding at the time? Do you see that?
Yes, sir, I do.
Okay, so what was your understanding at the time? Was that a reference to Neil Cotty's gut feeling?
I don't remember discussing that specifically. I do recall being informed that there was a $1 billion contingency in this $5 billion forecast, and that seems to correspond to the Neil gut line there.
Well, when my staff interviewed Mr. Cotty, he said that the November 12 forecast was of questionable validity. He also said that he did not have time to delve deeply into the details of the forecast. Did you know that Mr. Cotty had not delved deeply into the details of the forecast before a billion-dollar guess
No,
called
sir.
Neil's gut was added to it?
No, sir.
Did the words Neil's gut create any concern in your mind at all that it might be a number pulled out of the air, a gut feeling?
I understood that this forecast was in part a guess, that it was an estimate.
Okay, so it was in part a guess. My understanding is you did not transmit the November 12th document to the attorneys at Wachtell Lipton. The record portrays you, sir, as the individual who relayed the relevant financial information to your outside counsel. Do you recall telling the Wachtell attorneys on November 12th and 13th that the October losses were $7 billion and that Merrill Lynch could break even in November, allowing you to spread October's losses over 2 months?
No, sir, I don't recall that.
But if you look at the documents here, you are quoted, and to members of the committee, as saying that in a conversation with Nicholas Demo, that you said that that Merrill Lynch lost $7 billion so far in October. How do we get the number out? And that also in the meeting notes of Wachtell Lipton attorneys, your comments are mentioned again relating to the $7 billion number. Now, when you spoke with your attorneys at Wachtell Lipton, did you recall telling them that the fourth quarter forecast received from Merrill Lynch omitted November-December projections for CDO, CDS, and subprime mortgage-backed securities, which alone lost $6.4 billion in October?
No, sir, I recall telling them that I had received a forecast from the Finance Department, and I described for them what the bottom line numbers were.
Mr. Meopolis, do you happen to know what the quarterly loss for Merrill Lynch turned out to be?
For the fourth quarter, my understanding was approximately $15.3 billion after taxes.
Well, in conclusion, Mr. Chairman, in other words, the actual losses acknowledged just 2 weeks after the shareholder vote were well above the threshold that would have led you to recommend additional disclosure. In fact, if Bank of America had simply extrapolated October's losses into November and December, you would have come pretty close to the actual magnitude of losses for the quarter. But neither Merrill Lynch nor Bank of America did that, or any financial analysis at all. Mr. Chairman, they relied on someone's gut feeling.
Yeah.
Yield back.
Thank you very much. And I yield 5 minutes.
Thank you, Mr. Chairman. Let me just try to tell the story the way I see it unfolding. So last fall, you make a decision, or circumstances such that you're going to acquire Merrill. In the midst of all that, the TARP bill passes. Through our testimony we got from Mr. Lewis earlier this year, he indicated 9 days after TARP passes, the biggest financial institutions are brought to Washington. They are told they need to accept TARP money. He makes a call to board members and decides to do that. In the midst of all this last fall, you look to exercise the MAC to, in my judgment, put more pressure on Merrill because you see they're losing more than you initially thought. You want to get a better deal, what two businesses do all the time. The government said no to that. In fact, based on testimony we've heard, even though Mr. Moynihan, in answering the chairman's question, said differently, and based on what we've heard, there was some kind of at least subtle pressure placed on Bank of America to go through with the deal. In fact, we have the letter from Attorney General Cuomo which suggests that, says that Mr. Lewis and the board would be gone if, in fact, they did not follow through on the Merrill deal. You sought assurances, as Mr. Issa pointed out in his questioning, from the incoming players, likely players in an Obama administration. You actually sought them in writing. They said they wouldn't put anything in writing, but our assumption is you got some kind of verbal assurances to proceed further with this. So let me just ask a couple questions. Is that in fact the case, that you received assurances in some form, other than writing, from the likely folks to be involved in the Obama administration at the Treasury Department, that if in fact things got worse, they would be there with additional TARP dollars to help Bank of America? And we can go right down the list, and I'd like a yes or no to that if we could. Mr. Moynihan, we'll start with you.
We received statements from the current Secretary Paulson and Chairman Bernanke that as we worked through from mid-December in the 2 weeks we had to work through it, that if we went forward, that we could would receive some sort of assistance, which we finally negotiated and actually closed in January of 2009. As to the statements of the incoming administration, I think Mr. Lewis has testified to that he, in his conversations with those people, he was told that they had heard about the transaction. I was not part of those discussions.
Yeah, so I just want to be clear. Was there a promise made from the incoming Obama administration that they would be there to back you up if, in fact, that's what Bank of America needed?
I don't know that because I was only told what Mr. Lewis's conversation was, which I assume.
Mr. Gifford?
I was aware of no such promise.
Mr. May? Mr. Mayopoulos?
I was aware of no such promise.
Okay.
Neither was I.
Were you aware of assurances? I mean, something short of the word promise. Were you aware of that?
As I understood it from our chief executive, he was told, or he told, that
And he related that to you?
he related that to
Okay.
us, that the new members, the new administration, were aware of the discussions.
Okay.
Not
Mr. May,
implying-
would you agree with that?
We were being apprised pretty regularly of the progress that was being made from the
Okay. Let me
mid-December
move
meetings.
to the end of the story here, or at least what we hope is the end. Kind of cut to the chase of where we are today. How much TARP money has Bank of America received?
We've received $45 billion in total.
$45 billion. And what is your cash position today? You've said, all of you said this was a good deal, it's worked out for the shareholders, you know, wonderful apple pie, God bless America, the whole thing. So what's your cash position today?
Our cash position is in excess of around $150 to $200 billion.
Have you paid back the TARP money?
We have not paid it back yet. We've been clear that our goal is to pay it back as soon as possible.
And why haven't you paid it back, Mr. Moynihan?
As last week they issued a series, the federal government issued a series of requirements to pay it back, and we're looking at those. And
Have you asked the federal government to pay it back? Yes or no?
It's not.
Have you got permission? I mean, what's preventing you? You got a $150 billion cash, positive cash position, and you owe the taxpayers of this country $45 billion. Why hasn't it been paid back?
As you could look at the guidelines, it takes a series of steps and a series of requests and answers.
If you could, would you pay it back?
If we could, yes, we would pay it back. We've been clear with our intention to pay it back as soon as
And
we
is there, in your judgment, are there hindrances or obstacles that the Obama administration is putting in place that are preventing you from paying it back?
I think the question that the government's looking at this is to make sure we can all stabilize the economy, which was the intention. And I think as I said earlier, we've done a pretty good job of doing that, as have our colleagues that received the money. And I think
in your professional judgment, why the hindrances? Why can't you get that money back to the federal government, pay back the taxpayers?
I think we just have to be assured that if we do that, then the economy is in the kind of shape, and for a company like ours, which supports America and around the world businesses, that we can.
Would you agree that, in fact, in October we ran the highest deficit single-month deficit in American history. Last fiscal year ran the highest single annual deficit in American history. Wouldn't you think that the new administration would want that money to get back into the Treasury and help with that situation?
I think you'd have to ask them that. Our intention would be paid.
Gentleman's time has expired. Yeah. Let me ask all of you to pull your mic closer. We have some senior citizens up here having trouble hearing. Yes, I yield to the gentleman from Maryland, Mr. Cummings.
Thank you very much, Mr. Chairman. Mr. Moynihan, I find your testimony very troubling. And I don't know who you think we are, but I got to tell you, I find some of the things that you've said not believable. First of all, the chairman asked you why Mr. Mayopoulos was fired. A seasoned attorney was fired 9 days after he gave an opinion, and you basically said you all suddenly got into downsizing fever. Is that right? Is that basically what you're saying? You were downsizing?
I said I wasn't personally involved in the decision, but it was in the context of.
Well, you replaced him, didn't you?
Yes, I did.
And what were you told, what did they tell you, and I remind you that you're under oath, was the reason why he was fired?
Ken asked me to take the job as general counsel, and I said I would take
I'm sorry, say that again?
Mr. Lewis asked me to take the job as general counsel, and I said I would take the job.
You didn't answer my question. I said, were you told you're replacing somebody, you hadn't practiced in years, and you're replacing somebody who's a seasoned attorney who had just given an opinion that apparently Mr. Lewis did not like, or others did not like, And you mean you're walking into a job and you didn't say, well, what happened to the last guy? I mean, that's a logical question.
That's absolutely a logical question.
And what did you find out? Did you ask the question, first of all, or did you know?
I didn't ask the question, and I went about doing...
So you didn't care, right?
I cared of Mr. Myopoulos as a person, obviously, but I met with his direct reports and started my job.
And if you were advising a client the size of Bank of America, what would you say to the management if they told you they wanted to fire their in-house counsel and replace him with a senior business executive who, while a credentialed, an experienced attorney, had not practiced law in 10 years and was not even licensed at the time? Would you advise them to make that move?
I think if the decision was made for me to be general counsel, I think it was a wise move on behalf of the company, and I was competent to do it.
That's very interesting. Now, let me ask you this. You had an opportunity to talk to our committee staff, did you not?
Yes, I did, sir.
And you believe that there was a MAC was appropriate. There was a case for a MAC. Is that right?
I believe we had a valid claim for
And
MAC,
at the
yes.
time that you talked to the committee staff, you produced no evidence with regard to why you had that opinion. Do you have any evidence today?
Representative, the evidence is that in the fourth quarter of 2008, Merrill Lynch lost $21 billion pre-tax, and it was not clear that they'd be able to use the tax benefits. That was twice as much as they'd ever made as a company, and completely depleted their capital by 50%. And so therefore, that was a material change in their circumstances. Their ability to earn money at the level they were supposed to was impaired by their capital have gone down.
Now, that was inconsistent with the law firm Wachtell and what Mr. Myopoulos had said. Is that right? Was that inconsistent? In other words, you all had hired a big law firm, and you had a general counsel, and then you come in, you haven't practiced law in 10 years, and you come along and say, I think this is a good time, but the MAC is fine. So I'm trying to figure out, how'd you get there?
I relied on Wachtell Lipton, who was of the same opinion. We had a valid claim for MAC and informed us such. I also relied on my experience in dealing MAC clauses and having taken apart deals for MAC clauses in my experience in the past, the hundreds of deals I've done as an attorney and a business person. And we were all of the same opinion, that this was, at $21 billion in losses, this was a material change in the circumstance of Merrill Lynch that we had to address.
Well, let me get to Mr. Myopoulos, because apparently he had a different opinion. Is that what Wachtell had said, Mr. Myopoulos? He says that they were all in agreement. Is that right? That's not what they told you, is it?
We didn't have any conversations. I didn't have any conversations with Wachtell about the material adverse change clause.
All righty. Now, Mr. Gifford, this is the fellow, Mr. Moynihan is one of the people that you are considering to take Mr. Lewis's place. Is that right?
That's what I read in the newspaper, sir.
That's what you read in the newspaper. What do you mean?
We have tried very hard, Congressman Cummings, not to be talking publicly about individuals.
Well, the fact is, the reason why I'm talking about it is this the guy, I'm just trying to figure out, is this the guy that we've got to face when we are trying to deal with Bank of America, when we've got $45 billion invested in a company? I'm just trying to figure out, is this the face that we are going to be facing?
And I'm responding, Congressman.
And I'm not asking you for your decision. I'm just asking, is he is one of your top candidates?
He is a very talented executive at Bank of America.
Thank you very much, Mr. Chairman.
Thank you very much. I now yield to Mr. Lukenmeyer from Missouri.
Thank you, Mr. Chairman. I'd like to follow along this line of questioning. Mr. Myopoulos, in our documents here, it indicates that you informed Mr. Price that Bank of America did not have the basis for invoking a MAC. What was your basis of that decision?
The basis of that decision was that in order for there to be a material adverse change, there had to be an event that had occurred that had a disproportionate impact on Merrill Lynch in contrast to other companies in the industry, including Bank of America. And as I discussed with Mr. Price, the stock price of Bank of America had declined almost as much as Merrill Lynch's. Bank of America had gone out and raised substantial capital. It had cut its dividend. Its earnings had been reduced. So basically, both companies had suffered significant downturns in their prospects in the time since the merger had been announced.
Was the information that you had, did you not have the information that Mr. Moynihan had with regards to the $21 billion loss at the time that you made your advisory opinion to Mr. Price?
That's correct. I did not have that information.
Okay, if you'd have known that, what would your advice have been at that time?
I believe my advice would have been, although I don't have all the information that the company had at that time since I was gone, but my view would have been that invoking material adverse change clause would be a dangerous and risky prospect, but I didn't have the information and I didn't study that question.
So what you're saying is you would have gone along with saying that the MAC would have been a very viable way of to go ahead and invoke MAC then?
No, sir, I'm not saying that. I'm saying that I think it would be a very difficult decision to invoke the material adverse change clause. I believe I would have suggested that the company sit down with Merrill Lynch and try to renegotiate price, but if that didn't work, I don't know that I would have threatened to invoke the material adverse change clause.
Well, do you believe then that the reason that the MAC was eventually then used as a bargaining chip, or was it used as a bargaining chip in your judgment to extract a better price from the government?
Congressman, I don't know what it was used for. I was never privy to any of the discussions. I was gone.
Okay. Along this line also, obviously in a lot of our documentation here and in the testimony, there's the threat to fire Mr. Lewis as well as the entire board. Can you tell me, or any of you gentlemen can tell me the circumstances under which they, number one, had the authority to do that, and number two, the circumstances under which they believed that you as a board or as Mr. Lewis as chairman were doing something wrong that they could fire you for?
Well, I think the discussion about that is, I think, reflective of the very serious circumstances that we faced in December 2008. The economy was in a total disarray.
They're going to fire you for the economy?
The economy was in disarray. The regulators were serious about us thinking about the pros and cons and using our judgment around the MAC and what we would do as a company. And I think what I always took that as a view of how serious the situation and how serious they wanted to think about it. We were prepared, if it was the right interest for our shareholders, to exercise the MAC irrespective of what would happen to management, and I assume Mr. Gifford and Mr. May would say the board.
Unfortunately, Mr. Monahan, that answer does not fly with me. You cannot tell me that Bank of America is going to cause our entire economy to go down if you don't do this, and because of that they're going to replace your entire board and the chairman? You expect me to believe that?
The point, I think, was that would we feel that if we had to be removed, if the government said that we had to be removed, that did not factor into our decision.
So basically they were extorting your decision to go along and accept Merrill Lynch as a partner, business partner. Is that what you're saying?
What I said was that we did not let that factor in our decision of what the best interest of our shareholders was.
If I may respond as member of the board, Congressman Lutkemeyer, excuse me, we heard on, I believe it was December 22nd, the CEO reporting to the board that the government, Secretary Paulson, had made it clear that the government felt very strongly that this transaction should continue. It was in the best interest of the American financial system as well as Bank of America. And we also heard the comment, and if it doesn't happen, there is a risk to members of the board and management keeping their jobs. I can assure you, sir, as much as I care about the American financial system, our job is representing shareholders. And that did not one iota factor in the decision that I and I believe my cohorts made in proceeding with the transaction. To do so would be just directly dishonoring our fiduciary duty. And we made that clear in our discussions at the board.
Okay, I got one more quick question before my time expires. Obviously, Mr. Moynihan, you testified that they lost Merrill Lynch lost $21 billion. Can you tell me what the problems were, or why they lost that money, and have those problems been rectified now that that Bank of America owns the company?
The problems were due to the markdowns of securities and other things that were going on in December of 2008 as the markets continued to deteriorate. They are rectified because Merrill Lynch makes money, but the context of that is Merrill Lynch being owned by Bank of America with a stable capital base and ability to keep its balance sheet is now able to produce the kind of money and do the kinds of things for our customers which are strong. But in December 2008, that's not.
Do they still involve themselves in a lot of the investment derivatives type activity that caused a lot of the problems?
They continue to trade with their clients. I think a lot of the, quote, legacy positions that you hear people talk about are not being renewed or running off as we speak. but I think it's a much more straightforward, clear, and less risky platform than it was as a standalone company due to the stability and capabilities Bank of America and Merrill Lynch together had.
The gentleman's time has expired.
Thank you, Mr. Chairman.
I yield 5 minutes to the gentleman from Massachusetts, Congressman Turney.
Thank you, Mr. Towns. Mr. Gifford, at what point in time did you become aware that Mr. Mayopoulos was being relieved of his duties and that Mr. Moynihan was assuming a role as General Counsel?
I believe, Congressman Turney, it was the afternoon of December 9th. Sorry, I believe it was the afternoon of December 9th following a board meeting.
Okay, so that was the day before he actually had the unceremonious firing incident.
Having just heard the December 10th, yes.
Okay. Can you tell us what was discussed when you learned that he was being fired and that Mr. Moynihan was being hired?
I and the rest of the board, Congressman, was informed at the end of that December 9 board meeting that Mr. Moynihan was leaving the company because of he wasn't able to take a job that the CEO wanted him to take. A number of board members, within a couple-minute time frame, expressed regret because, as I said earlier in the testimony, Mr. Moynihan is one of the most talented executives I've ever worked with. And we expressed that regret to the Chief Executive Officer. At that point, I and a bunch of others that live in Boston got on a plane, went back to Boston. I, at that point, thought I knew nothing about Tim. All I knew was that Brian was leaving the company. When I returned to Boston, I got sometime late afternoon an email, as did all members of the board, from Ken Lewis, the Chief Executive Officer, informing him that Brian was staying in Bank of America and becoming General Counsel.
Thank you. Mr. May, were you privy to that same set of facts, the same conversations?
Yes, I was. That day at the board meeting, we found out that Brian was leaving the company. I did express to Ken Lewis a concern about that because of his versatility. I indicated he can play third base, he can catch, he can pitch. We've had him in almost every aspect of the business, whether it was wealth management, whether it was investment banking, or whether it was in legal. And we were happy to hear that he had found a solution. Again, you have to recall that this was at a time when a merger was going on, and so we don't usually use the word fired during mergers, but positions are eliminated. You have two treasurers, you have two controllers, you have two presidents, and things were being eliminated, and the
you don't
top
want us
management
to really
organization
think
was
that
shrinking.
this all happened in the context of the merger and you were shuffling positions around just at that critical moment, that instead of waiting until after the transaction was completed by the board, then you're going to shake out. You wanted us to think that while that was going on, you decided to do all that.
This absolutely was happening. Mr. Moynihan had been in investment banking. He was leading the Bank of America Investment Bank. The merger with Merrill Lynch not eliminated his position, but